Good day, everyone. I am Michael, the moderator for this webinar. I welcome everyone for today's webinar, which is the Anti-Kickback Statute, Perspective from a Whistleblower, Lead Counsels, and an Anti-Kickback Case Defendant. I would now like to introduce our presenters for today, William McCopeland and Barry Weinbaum. William McCopeland, MSJD, PhD, LFACHE, practices healthcare law in Harrison, Ohio at the firm of Copeland Law, LLC. Barry Weinbaum received his Master's Health Science Comprehensive Health Planning degree from Johns Hopkins University in 1977. I would now like to hand over the floor to the speakers. Over to you.
Thank you, Michael. Like the slide says, today we're going to talk about the Anti-Kickback Statute and perspectives from me, Whistleblower Lead Counsel, and from Barry Weinbaum, who's an anti-kickback case defendant. The objective today is to provide you with an overview of the Anti-Kickback Statute, its elements, what it prohibits, and how it works. And then we're going to let Barry review the case of United States v. Weinbaum. The most familiar, really, of the Medicare, Medicaid fraud and abuse statutes is a section of the Social Security Act, which is often referred to as the Anti-Kickback Statute. The statute prohibits the offer of payment. What constitutes any remuneration, however, is kind of a gray area. The statute itself prohibits, in its language, any kickback, bribe, or rebate. Cash payments in exchange for referrals violate the statute. Now, the intent of the statute is to eliminate the payment for referrals of Medicare, Medicaid patients, while the statute is primarily aimed at prohibiting payment to physicians for referrals. There are 4 specific exceptions. Because the Anti-Kickback Statute is extremely broad in its language. Now, this broad interpretation of the statute was adopted in the Katz and the Bay State case. Now, given the direction of judicial interpretation, the Medicare and Medicaid Patient and Program Protection Act may be viewed as an effort to respond to the concerns of healthcare providers. The Act modifies the criminal provisions by requiring the promulgation of regulations. In 1991, HHS issued the first final safe harbor regulation. Physician recruitment. The practitioner recruitment safe harbor protects recruitment payments made to persuade physicians to relocate or for new practitioners to locate, but only applies to hospitals located in rural or urban health professional shortage areas. An employer may pay an employee to solicit business. The OIG also issues special fraud alerts.
So the trials themselves, the whole ordeal, as indicated, started in March of 2002. And so as Bill indicated, we were talking about this is an intent-based statute, and did you set out to influence a referral source overtly or covertly via financial arrangement? So, here was the typical relocation agreement. And again, this was a model that Tenet came with. So what was the prosecution's theory? That, it started in 1992 when I started at the hospital. And the government was saying that the payments under the relocation agreements were wildly inflated. Well, our position was that no contract or payment was contingent or conditional, verbally or non-verbally, on the need to admit patients. So, next slide, Bill, you kind of asked your question, was this a perfect storm? So, again, we talked about some of these lessons that are learned and alluded to some of them. I think the good news, again, is that, did you knowingly or willingly set out to violate the law? Some advice and recommendations here regarding documentation. Correspondence with doctors, again, kind of picking up to what I was saying before, text and email, we tend to be sometimes sloppy. Some other additional advice and recommendations on some recommendations I have regarding your management staff and your organizational style.
All right, let's think about some recommendations for the Anti-Kickback Statute. Number 1, develop a good compliance program. You should also periodically conduct internal audits. Should review all contracts with physicians and other providers and pay particular close attention the contracts with. Develop a good training program to teach compliance to your employees and your contracted personnel. Make sure that they understand the law and they understand what is required of them. Develop a culture of compliance. Maintain quality of care. In conclusion, you are responsible for compliance.
Thank you all for the opportunity to present this information. We trust that you found it helpful and good advice. And just be careful out there.
Stay safe. Have a wonderful day, and the rest of you, the year, I hope is very pleasant for you. Thank you very much. Have a good day. Goodbye, Barry. Goodbye, Michael.
All right, Bill. Michael, thank you very much.
Thank you.
Yes,
So
Michael.
that does conclude the session for today. Thank you everyone for participating. You may all disconnect now. Have a great day ahead. Bye-bye.